Hi everyone, welcome back. Relevancy and admissibility of evidence with respect to Indian Evidence Act 1872. Relevancy. Relevant facts are connected facts. They are not part and parcel of the facts in issue. Relevant facts are ancillary or collateral to the principal facts. The collateral facts, when put together, make the facts in issue probable or improbable. The consideration of relevant facts will be helpful for the determination of the facts in issue. Evidence may be adduced on facts in issue and relevant facts only. The following are relevant facts. The first, facts which form the same transaction of the facts in issue. Now, facts which constitute the state of things under which the fact in issue happened. Facts which show motive, preparation, conduct, and so on. Facts which explain or introduce a relevant fact. Fact which show conspiracy or common design. Fact which are inconsistent. Facts which determine the damage. Now, facts which show the custom. Facts which show the bodily feeling. Facts which show the intention or accident. Facts which show the existence of business. Facts which show the admission. Facts which show the statements which are inadmissible and admissible. Public records and documents. Facts which form part of a statement, judgment of courts, opinion of experts, facts which show character. Then, all these facts which are intrinsically connected with the fact in issue are called relevant fact, and it is discussed from section 5 to section 56 of Indian Evidence Act 1872. The relevant facts may make the facts in issue existing or non-existing. Evidence may be given in any suit or proceeding of the existence or non-existence of every fact in issue. Now, logical relevancy and legal relevancy. A fact which is consistently important may not be lawfully applicable under the Arrangement of Evidence Act, thus would be forbidden in proof. All allowable evidence is significant. However, all relevant evidence isn't really acceptable. So that is the difference between logical relevancy and legal relevancy. All facts which are permitted by the arrangements of the Evidence Act to be demonstrated are pertinent. Yet, anyway, applicable a reality might be, except if it is permitted to be demonstrated by the arrangements of the Evidence Act, it isn't allowable. Now, admissibility. Relevancy and admissibility are not the same. Relevancy means what facts may be proved before a court. The rules of relevancy declare certain facts as relevant. The facts that are allowed to be proved under our Evidence Act are called relevant facts. Relevancy is to be determined by logic or natural connection to the facts in issue. Admissibility denotes legal relevancy. What the law admits as relevant is based on the rule of law. The admissibility is the means of proving the relevant fact. The rules of admissibility lay down as to whether a certain form of evidence may be allowed or excluded. For example, the proof of loss of the original deed is essential before secondary evidence about the contents in the deed is admissible. Distinction between relevancy and admissibility. Relevancy denotes what facts may be proved before a court, and admissibility denotes legal relevancy. Relevancy relates to facts and admissibility relates to evidence. The rules of relevancy declare certain facts relevant, and what the law admits as relevant is based on the rules of law. That is, admissibility depends on the rules of law. Now, all the facts which are so connected with the facts in issue that may make fact in issue existing or non-existing are called relevant fact. But in case of admissibility, when facts have been declared as relevant under the provisions of the Evidence Act, they become admissible. Now, relevancy. Connection between the facts must be proximate or reasonable and not remote. With respect to admissibility, consideration like public policy, speedy justice necessity, and like things operate to qualify facts as admissible. Relevancy is the cause and admissibility is the effect. So that is the distinction between relevancy and admissibility. The expression relevancy and admissibility are often used as synonyms. All logically relevant facts are generally speaking also legally relevant. However, relevancy is not only the test of admissibility. It is based on the tests like public policy, expediency, consideration of fairness, speedy disposal of cases, and so on. So, relevancy is not the only test of admissibility. Admissibility is also based on tests like public policy, expediency, consideration of fairness, speedy disposal of cases, and so on. The legal implication of the words relevancy and admissibility are the distinct and different. More often than not, the facts which are relevant may not be admissible. For example, communications made by spouses during marriage or between an advocate and his client, though relevant, are not admissible. Similarly, certain facts which are admissible may not be relevant. For example, questions permitted to be asked in cross-examination to impeach the credibility of witnesses, though not relevant, are admissible. So, in a case law, that is Public Prosecutor versus Dattoseri Anwar Ibrahim. Public Prosecutor versus Dattoseri Anwar Ibrahim, 1998. Here the court held there is overwhelming evidence to support PW1's allegation that he had been sodomized by DSAI. A judge is entitled in law to convict even without corroboration if convinced of the truth of a complainant's evidence. Here the court held there is overwhelming evidence to support PW1's allegation that he had been sodomized by DSAI. Now, a judge is entitled in law to convict even without corroboration if convinced of the truth of a complainant's evidence. So that was held in Public Prosecutor versus Dattoseri Anwar Ibrahim, 1998. Thank you for listening. That is the end of this part with respect to relevancy and admissibility. We will be covering the rest of the topics in the following parts. Stay tuned. Thank you for listening. Like, subscribe and comment and click the bell icon so that you can get an update when I upload my next video.